for this very nice invitation, which is a real honor to me. When Professor Juan Carlos invited me to this conference, he told me that I should give a 20-minute talk to explain what had been my most significant contribution to the law. And when I thought about it, I concluded that, well, if I have ever done a contribution to the law, probably the most important was the co-authoring of an introductory book to law, which is called Introduction to Public Law. And in fact, when I thought about it, although I've written in different subjects, from the relations between law and morals to religious freedom, from EU economic freedoms to state aid and subsidies, well, I really concluded that my most significant contribution was that written with my students in mind, my Portuguese students of law. And in Portugal, it's not, as a rule, normal to have an introductory course in public law. Normally, there's an introductory course to law. And so normally students start by studying constitutional law, administrative law, tax law, other branches of public law. But some years ago, in 2008, me and my colleagues were asked by the law school to teach this introduction to public law to first-year students. And so what happened is that we faced the challenge of knowing, is there really some distinctive features of all these branches of law, or should we just give and talk about some subjects of each of those branches? And as it happened, we concluded that there were some notable common features that allow the presentation of a general theory of public law. And I'll talk about those features in a minute. I'll also talk about another aspect that it's important in this context, which is taking into account in public law different sources of law besides domestic Portuguese law. Of course, we're in a Congress that has to do with, and is dedicated to natural law, and you'll see how all this is connected to natural law in a minute. But really my presentation is on natural law and public law in a multi-level context. Why a multi-level context? Well, because Portugal is, since 1986, a member of the European Union. And because of that, since that moment, EU law has been a part of, let's say, Portuguese law. It's applied in Portugal as if it were Portuguese law. It's a distinctive feature of European Union law that it produces direct effect in EU member states' legal orders. What this means is that EU law can be invoked before domestic courts of law and has to be applied by those courts in the disputes that they judge. And this results from a stable case law of the European Court of Justice for almost 60 years. And actually, in Portugal, something similar happens with international law, with public international law. According to the Portuguese constitution, international law is an integral part of Portuguese law. And so public international law provisions have to be applied by Portuguese courts. So as you can see, Portuguese courts will have to apply not only Portuguese law, so domestic Portuguese law, but also European Union law and public international law. And so this reality is what some have called multi-level law, or the multi-level reality of law, which is a reality today not only in Portugal, but in many European countries, and probably in other countries around the world, not regarding EU law, of course. And so what happens is that in Portugal and in these other European countries, the law that is in force in their territories is not only the law enacted by their legislatures or governments, but also the law made up by the European Parliament and the European Council, and the law resulting from international treaties, and in some cases, resulting from decisions of international organizations. So all these provisions of law, wherever they come from, whatever their source, will have to be respected by individuals, by private and public entities, and will have to be applied by national courts. So the challenge we faced when we thought about teaching and later writing a book on introduction to public law was, first of all, finding those common features to domestic branches of public law, but then also common features to these other legal orders, European Union law, public international law. And besides that, we tried to find a framework to integrate domestic, European, and international law so that our students, obviously, but any subject of law in any court could know how to cope when having to apply different provisions coming from different sources, not all of them domestic. And of course, this problem is made even worse, for example, in federal states, where then besides that eventually European and international level, you then have a federated level of law and eventually even a regional level of law. And this could lead to 4 or 5 different levels that will have to be integrated. So to which conclusions did we come about regarding the common features of public law? And then we'll see how this connects to the issue of natural law. Well, the first one is that, of course, public law applies to relations between public entities, namely states, but also other public entities on the one side, and individuals or other legal persons, which may include other public entities on the other side. So when we're talking about public entities, besides states, we're talking about federated states, regions, municipalities, public companies, other institutions, but also international organizations, supranational entities like the European Union, EU agencies. So there's a wide variety of public entities that we're talking about. And public law refers to these public entities and to the relations they entertain with other entities. Now, that's the first feature. The second feature is that in those relations, the most salient characteristic, let's say, of public law is the conferral on those public entities of legal powers to unilaterally and without consent change the rights and duties of those individuals, those legal persons, and then demand compliance with those obligations which were created in their legal sphere. And of course, there are many examples of these powers, those of adopting, well, first of all, the Constitution, and then laws, statutes, regulations, directives, in some cases also international agreements, international treaties, but also powers, for example, to adopt court rulings or to approve and enforce administrative acts. So all examples of legal powers that unilaterally, without consent, change the legal sphere and the set of rights of duties of other people. And of course, these first two features of public law, the existence of states and the creation of other public entities, which then are going to be regulated by public law, and the conferral of those major powers, that creation and that conferral happens all in order and only in order to allow for the pursuit of the public interest, of the common good. And when we talk about this, we normally distinguish between primary interests. The guarantee of peace and security, the administration of justice for all, and pursuing people's in general well-being. And then, of course, there will be secondary interests that will be defined by law. Now, the thing is that for all these three aspects to work, there has to be an element, another one has to exist, which does not pertain to the legal domain, but to the realm of facts. And I'm talking about the capacity of a state to impose by force. So to enforce normally has last resort, but to impose by force the obligations of legal subjects. And to this capacity to use force unopposed in a certain territory, we call, of course, sovereignty, which I would say, well, it is normally required. The contrary would be anarchy. So a situation where that sovereignty does not exist. I've never met a situation where that worked well, at least contemporarily. That doesn't happen. So we know when we talk about domestic legal orders that their effectiveness depends on the existence of a sovereign state. But that is also the case regarding EU law. Although in the case of EU law, the effectiveness of EU law does not depend on the existence of a European megastate, but depends on each 27 member states being willing to enforce EU law provisions. And that is, of course, also the case with public international law, which will be applied and complied with as long as states are willing to. So, as you may notice, for all the talk about globalization, deterritorialization, states' loss of power, in fact, the effectiveness of all levels of law still very much depends on states, on sovereign states. The problem with all this situation that we are describing is that this panorama that we're describing is full of power. So we're talking about the power of brute force sovereignty. We're also talking about unilateral legal powers that do not require consent of their subjects to produce legal effects. And why is this a problem? Well, has been known for centuries, for millennia, although it was 19th century Lord Acton that put it into words in his letter written to Bishop Mandel in 1887. Lord Acton said, as is well known, power tends to corrupt and absolute power corrupts absolutely. And the problem is that, as we've just found, and we all knew, we have this brute force power that is granted or taken by the state. And in history, several expressions were used that reflect concrete regimes that existed and that translated into the reality these words by Lord Acton: tyrannies, absolute monarchies, dictatorships, authoritarian states, totalitarian states. But if this is so, we seem to be stuck until this moment in a paradox. So we said, in order for the common good to be attained, for public interest to be pursued, we need states with unilateral legal powers and able to use force in last resort. However, entities with such a power will tend to abuse that power and tyrannize its subjects, therefore compromising the common good. Now, of course, the way out of this paradox has been slowly, sometimes abruptly, construed since the 18th century. And so several instruments, mechanisms to control power have been found, tried. Separation of powers, when we're talking about the internal organization of states, the balance of power when we talk about international relations, the federal organization of the state, the existence of constitutions or human rights treaties in the international arena, the recognition and enforcement of a rule of law that applies not only to citizens, but to public entities, to states. That's actually why public law exists. The existence of independent domestic and independent international courts, the civil responsibility of the state, the existence of a democracy. So all these are or are also instruments to control power, to prevent the abuse of power. And in fact, of course, we talk about all those aspects in the book, for all these organizational, institutional, legal instruments that were created or found in history and tried in history to contain power. And finally, and this is where natural law enters in this story, we talk about the recognition that there are some fundamental principles, some fundamental rules that cannot depend on being enacted by a legislator or a government to be valid, to be respected, and crucially, to be applied by courts. So this is clearly, at that moment, we enter in the domain of what was classically designated as natural law. And of course, we could and we do talk about the fascinating intellectual history of natural law, since the early Greek philosophers to modern European thinkers. We talk about the foundations that were proposed to these rules of natural law: God, reason. We talk about then we'll talk about, and we talk about, legal positivism. So this idea that all the law that exists is the law approved by the instituted power, and that is it. There's no law besides that, which was the dominant legal doctrine in the 19th and at least in the first half of the 20th century, and that many still well, think about that. So what happened to convert, let's say, many legal thinkers to an alternative way of looking at the law? Of course, World War II and all the horrors that happened at that moment. That really was a wake-up call for all legal positivists, and that war exposed once again the horrors that might result from unlimited power. And so after World War II, we had German thinkers, German legal thinkers, that start thinking a bit, well, if only German courts could have invoked something in order not to apply and comply with those Nazi legal provisions, maybe they could somehow have prevented all those horrors. The problem at that point in time was, and as we've been seeing in this Congress still is, how can these fundamental principles and rules be justified? Now, in the plural societies of the 20th century, religion was no longer a consensual answer. Of course, if you believe, and to those who believe, that could be the answer, but not to those who do not believe. And so we have to find a different justification in a plural 21st century society. In the past, of course, it was thought that through reason, one would discover the true human nature, and we would extract from that analysis the rules of natural law, but that had already been put in question long ago by Kant and others. So and so they had to find a different answer, and the answer they did, and which still seems correct to me, was to found these fundamental rules and principles of law in the shared moral beliefs of a human community, in what we normally call a general ethical conscience. Now, on the one hand, because this coincides with a certain sociological analysis of the origin of power. Some sociologists claim that in the end, all power is based on a tacit, at least tacit consent on the part of the governed people. Even authoritarian regimes are dependent on the absence of a people's uprising. And so if they do not start a rebellion, it's because tacitly they consent with that power. So if this is so, if the origin of power is people's consent, and of course that is claimed in all democratic countries, if the origin of that legal power that we talked about, that constitutional and legislative power, is in the end the people's express or tacit consent, then one could argue that that power should be limited by that same people's core ethical beliefs. And so when courts, for example, say that they judge in the name of the people, that's an expression that is used in many countries, they could consequently and rightfully enforce fundamental principles and rules that are part of that people's core beliefs, even if not adopted, and especially if not adopted by that country's powers. Now, on the other hand, what this theory entails is that natural law is not necessarily the same, not necessarily equal everywhere and in every time, that it could change as history unfolds. It could be different from country to country. And so one has to abandon somewhat that classical idea of natural law that comes still from Aristotle, that says that if the fire burns the same way in Greece and Persia, so other rules that rule human behavior could be found to be equal in Greece and Persia. And according to this justification that we found to natural law, that would not be necessarily the case. But the thing is that there isn't only, or the only human communities that exist are not only those of states. We have wider cultural communities. And so one could observe, and one does observe, the appearance and recognition of common values in geographical spaces that are wider than each country's territory. That is clearly the case in Europe with for example, the European Convention on Human Rights. But of course, that could also be true in other geographical contexts, in other geographies. And in fact, I think that is what has been discussed here in this conference regarding the Ubuntu tradition in Africa. Okay? So a wider geographical area with a common ethical tradition. And we don't have to even stop there, because there is the human community of Earth as a whole. There could be, and in fact, I believe there are common values to the whole of humanity. And since the Nuremberg trials after World War II, this conviction was stated and then developed that there are some essential values common to humanity that should limit any power. And later, that originated the jus cogens doctrine. The jus cogens doctrine, the doctrine of the peremptory norms of international law, and that came to be adopted by the Vienna Convention on the Law of Treaties and the International Law Commission when it wrote the project of Articles on State Responsibility. And what this doctrine says is that there are, in fact, some rules of international law that are peremptory, in the sense that they do not have to be accepted by states to be in force and to bind them, and also that cannot be derogated. Now, in the Vienna Convention, and even the International Law Commission did not clarify which rules of international law are jus cogens rules, but the doctrine and some courts' rulings do give some examples of these essential rules. It's a limited set of rules, but which would include the prohibition of slavery, the prohibition of genocide. And yesterday there was that great talk about the very sorry genocide in Rwanda, the prohibition of torture, and the prohibition of aggression. And well, aggression in this case, that is the unlawful use of force between states. Now, regarding this later aspect, I do not have to explain today how this is relevant. So at the moment when this major power, Russia, initiated an illegal, clearly illegal and unjustified war on another state, Ukraine, so it's time to affirm again that not only this act of aggression is an infringement of the United Nations Charter, but that it goes against a peremptory rule of international law against jus cogens that results from humanity's shared set of essential moral beliefs. Regarding this, as you see, we can find a world natural law, jus cogens, regional natural laws, and each state natural law, and eventually one could even find sub-state natural law. I'm just getting to the end of my presentation. As I told you, one of our ambitions when writing this book on Introduction to Public Law was also to create a framework where to put all these legal orders, all these levels. And of course, I will not enter into the details of that framework, but just for this purpose, suffices to say that it involves a hierarchy. And at the top of the hierarchy, what do we find? Well, we find the fundamental principles of law and jus cogens, that is contemporary, international, European, and in our case, Portuguese natural. Finish by just invoking the motto that Professor Juan Carlos asked for me for this conference, the idea of natural law, that there are fundamental values that must be respected by all authorities, can and should be affirmed in every time and in every place. Thank you for your patience, and I'm looking forward for your questions.